Shareholders at war, court influenced by expert accountant on true value of business. As is common in such shareholder disputes, emotions ran high, causing the judge to observe that at times the complaints have seemed more suited to a defended divorce than an unfair prejudice petition. In a recent shareholder dispute case, the court was persuaded by expert accountancy evidence given by Milsted Langdon's forensic partner, Roger Isaacs. The case of Richard George v. Robert McCarthy and Goss Interactive Limited, the company 2019, EWHC 2939, ch. concerned a petition brought by a 50% shareholder in the company alleging unfair prejudice under Section 994 of the Companies Act 2006. Mr. Isaacs was instructed on behalf of the respondent and another 50% shareholder. In addition to having to consider whether the petitioner had been unfairly treated, the judge considered the value of the company, which provided websites and digital platforms to customers that included a number of local authorities. Both the petitioner and respondents had appointed forensic accountants to opine on the value of the company and the petitioner's shares therein. Experts' views. The experts agreed that the company should be valued by applying a multiple to the expected future earnings of the company and that an adjustment was then needed to reflect the fact that it had surplus cash deposits. However, the experts held widely differing views as to the level of the maintainable earnings, the appropriate multiple and the amount of surplus cash. Consequently, the petitioner's expert valued the company at £5.8 million, which was a figure almost 4 times the value attributed to it by Mr. Isaacs on behalf of the respondents. The huge difference in valuation was probably one of the reasons why the case did not settle at mediation and resulted in a fully contested trial. Despite the experts having met to try to narrow the issues between them, the gulf remained unbridged and it fell to the court to make a determination. When considering the value of the company, the judge referred to Mr. Isaacs' practical experience, which caused him to prefer his evidence and to conclude that the petitioner's expert's multiple of 10 was too high for a business whose performance was solid but unexciting. The petitioner's expert had adduced a wide selection of published figures showing actual figures paid for companies in the past to support the choice of a high multiple. However, the judge was persuaded by Mr. Isaacs' telling observation that such quoted statistics. For more on this story, visit the news article link.